Good morning or afternoon or evening or good night to all of you. This is going to be the first of a couple of review videos that I'm going to put together to get us ready for the AP exam. So for this video, we are focusing on Unit 1 for the AP Unit 1, not necessarily all of SARDO Unit 1, which is Foundations of American Democracy. This is really focusing on constitutional principles, ratification of the Constitution, debates over the Constitution. And this is 15 to 22% of the exam. And I'd actually argue if you have a good understanding of the constitutional structure and the general conceptual analytical frameworks at work in the Constitution, right? Like representative democracy, separation of powers, checks and balances, things like that, federalism as well, that can go a long way beyond just the kind of explicit questions that are about the Constitution, but a lot of those principles and those constitutional framework is at work in Unit 2 when we're talking about the structure of the federal government. It's at work when we're talking about civil liberties for Unit 5. So it's really important to have a good grounding understanding of the Constitution. So this is going to be a quick diagnosis of what do you need to know. What is College Board expecting you to know from this unit? This is straight from the CED. So to give you these are the types of things that you're going to be asked questions on. First, can you explain how democratic ideals are reflected in the Declaration of Independence and the U.S. Constitution? So that means being able to define democracy, identify aspects of democracy and different types of democracy in the Declaration, rhetoric and structure of the Declaration of Independence and Constitution. Looking about different models of democracies, pluralist, elite, participatory, and how those are at work in concrete institutions and practices, comparing and contrasting the Federalists and the Anti-Federalists. Are you able to distinguish between their views and contrast them and evaluate them? Talking about the Articles of Confederation and the debates and limitations and strengths of the Articles of Confederation. Looking at the practices of writing the Constitution, what were the conflict, what were the compromises, and how did the Constitution get developed? Focusing on the kind of principles that are underpinning Federalist 51 here with the checks and balances and separation of powers. I'm actually going to do a separate video on the required foundational documents where I'll go into more detail there, but we're going to at least broach that in this video. Looking about how the separation of powers, checks and balances affect the political system, and we'll get more concrete about this in Unit 2 when we look at how the different branches of government specifically check and balance each other. Talking about federalism and the allocation of power between the national and the state governments, and how the balance of power between the national government and the state government has changed over time based on Supreme Court interpretations, and how this affects policymaking. So if we want to start with these ideas, let's start with this first idea. What is a democracy? Right? And so a democracy is really an answer of the question of who rules, right? We can look at a monarchy means one rule, an oligarchy or an aristocracy means that some rule, and a democracy means that everyone rules. Now, when we say a democracy, we don't always mean the same thing. Sometimes we're talking about a direct democracy, right? Where the people as a whole directly participate in politics, right? This is the model of the Athenian assembly where everyone can participate. This is the model of where you would choose your representatives not by election, but by a lottery, where everyone is able to have an equal chance of being in the government, right? And this is going to empower the ordinary people. The next one is the representative democracy, or what people call the democratic republic. And here, rather than the people ruling directly as a whole, the people choose representatives who engage in politics in their name. They pass laws in their name, they pass regulations, they make decisions in the name of the people, and they are held accountable by the people, but the people are not doing the day-to-day governing, right? People elect representatives. This was the model of the Roman Republic, and this is really the form of government, this representative democracy, that the founders preferred, that the framers of the Constitution preferred, because they were deeply skeptical of the ordinary people, of the common man, of the ability for ordinary people to really grapple with the issues of the day and rule effectively. But even then, we can break down representative democracy even further, right? We can talk about, on the more extreme end, or the more participatory, more direct end, we can talk about a participatory democracy, where the citizens actively participate in politics and civil society, not just by voting frequently, but contacting their representatives, attending town halls, writing letters to the editor, protesting, right? The citizens, as citizens, are actively participating. We could have a pluralist democracy, and this is more about the citizens able to organize into groups and exercise those groups through their power through these groups and influence kind of policymakers through collective power. And then we can have a model of democracy, which is we call elite democracy, in which most citizens have limited participation. They vote every 2 or 4 years in elections, and then they are voting for this elite or that elite. And they kind of let the elite, political and economic elites, make the decisions, and they're choosing which of these they most prefer. And these can be empirical descriptions. We can use these as ways to describe, like, what is the United States democracy? Is it more like a participatory democracy, pluralist, or elite democracy? But we can also use these as normative concepts, and we can say, like, this is the right way that we should organize a democracy. Now, obviously, a participatory democracy is going to be closer to a direct democracy, and an elite democracy is going to be closer to oligarchy, if we're trying to put this on our spectrum over here. So let's take a look, thinking about with these concepts in the back of our head, at the kind of movement from the Articles of Confederation through the ratification to the actual constitutional structure of the country itself. So we're going to start here by looking at the Articles of Confederation. Now, the Articles of Confederation were the Articles of Confederation and Perpetual Union. This is one of those required foundational documents, but more importantly, this was the first form of government of the United States in North America after its Declaration of Independence in 1776. The Articles of Confederation basically conceived of the United States as a union of sovereign states. What that means is that Virginia, New York, Delaware, Carolina, right, were all conceived of as independent and sovereign. Each state was the primary political unit that united together in a confederation, not a national government, but a confederation where they would work together for common defense and economic means, right? The idea here was that your primary political allegiance was to your state, and each state would be sovereign and independent, and they would work together with the other states for the common defense and general welfare. Structurally, the legislature of the Confederation Congress was a unicameral legislature where each state delegation had one vote. The Confederation government had limited powers. They could not tax, they could not raise a standing army, they could only request funds, and for any major legislation, it required a supermajority vote, so more than just a simple majority. It required 9 votes. There was also no federal judiciary and no chief executive, right? They did not trust these kind of powers. It was basically a way of passing laws that would govern the kind of relationships between and among states. Now, this created certain limitations, as you can expect, right? There's no taxing power, no standing army. There's no monopoly on coinage, which becomes really important because each state was issuing its own money and it got pretty chaotic. Now, it did achieve some good things, right? It did negotiate the Treaty of Paris, which ended the Revolutionary War and recognized American independence. It did pass the Northwest Ordinance, determining how the Northwest Territories that was acquired to the United States in the aftermath of the Revolutionary War would be met. But it also created a debt crisis in which basically people didn't value the money being printed by the states. States were in massive amounts of debt, and it was uneven debt, and there was no way to kind of like nationalize that credit. And we saw this kind of the biggest outcome in Shays' Rebellion in Massachusetts, in which a tax protest by a Revolutionary War veteran over back payments led to the seizing of a federal armory, and eventually the federal government the Confederation government, proved to be basically impotent to stop open rebellion. So a bunch of people met in Annapolis to do a quick coup and rewrite the Articles of Confederation, not merely amend it, but they ultimately developed an entirely new form of government. Now, it's important that when we're thinking about the form of government that is established by the framers in Philadelphia, that we recognize that these is not a philosophical document, but a political document that is the outcome of conflict and compromise. So one of the first areas of conflict was this debate between the federal government and the states. How much power should the federal government have, and how much sovereignty should be retained by the states? And the framers ultimately decided on a system of federalism. So rather than a national unified government, or that would basically eliminate states, or a confederation, which would basically keep the Articles of Confederation, they tried to split the difference, where there would be specific powers, and we'll talk about this towards the end of the video, that were entrusted to the federal government, and specific powers that were entrusted to the states and local governments, right? By dividing these powers, the framers of the Constitution sought to maximize the benefits of both a national unified government and able to pass laws binding on citizens of all of the states, as well as allowing each state to pass laws and policies that would be best suited to the particular needs of that state. There was also the question of how much power should individuals retain against the federal government, what type of rights that they should have, and versus the need for maintaining political order. Now, originally in the Constitutional Convention, the framers did not believe that a Bill of Rights was necessary. Alexander Hamilton, in one of the Federalist Papers, actually argues pretty strongly against the inclusion of a Bill of Rights, but ultimately the Federalists, in the course of the ratification debates, admitted that we could add a Bill of Rights, and it was the first 10 amendments of the Constitution were the first things that Congress voted on when it was convened. Then there was the question of how states would be represented in this national Congress, right? New Jersey wanted a unicameral legislature based on equal representation to protect the interests of states with lower populations, and Virginia wanted a bicameral legislature. That's a two-house legislature in which the representation would be determined by population. That would better suit the interests of larger population states. Ultimately, they compromised with a bicameral legislature in which the lower house, the House of Representatives, was apportioned based on population, and the upper house, the Senate, was equal state representation with 2 senators for each state. There was also the question of enslavement, right? To what extent would slavery be recognized in the new Constitution? This was both a question of sectional divisions between North and South. There's going to have economic questions of the slave trade, and it was also going to deal with representation. Ultimately, there's a series of compromises, such most famously is the 3/5 compromise, which for the purposes of taxation and representation, enslaved people will count as for the purpose of assessing population, they would count all free persons and 3/5 of all other persons. Now, the word slavery doesn't actually exist in the Constitution until the 13th Amendment, in which outlawed slavery, but everyone knew what that meant, that slaves would count as 3/5 of a person for the purposes of apportioning members of the House of Representatives. Article 1 also prohibited Congress from outlawing the slave trade until 1808, the international slave trade, that is, not the domestic slave trade, which it couldn't regulate. And in Article 4 of the Constitution, there's a provision that says that any enslaved person who emancipates themselves and escapes to slavery has to be returned to their owners. Then there was the question of a chief executive. Who would be ultimately in charge of enforcing and executing the laws passed by this Congress? How many people would it have? Would it be a monarchy? How would they be chosen? They ultimately decided, again, to split the difference with a unitary executive, so that would be elected, so not a monarchy, a lifetime monarchy. You would have 4-year terms. But they would be elected not directly by the people, but through the Electoral College, and they would have limits on the presidency through checks and balances. The last issue of debate was over the judicial branch. How much power should the judicial branch, how should they establish a federal court system, and what would their relationship to state courts be? Now, they kind of punted on this question because Article 3 just says that there will be a Supreme Court and that Congress would make other courts. They couldn't actually come to a compromise, and their compromise was someone else will figure this out for us. So let's take a look at the Constitution itself. It starts with the famous preamble. The preamble says, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." There is a lot to unpack here, but we can think of this as primarily establishing the idea that the power flows from the people to the government. The government is then supposed to provide certain goods for the people, such as the common defense, the general welfare, protect domestic tranquility, and equal justice, and is to maintain liberty and for ourselves in the future. And that is the kind of mission statement of the Constitution. The first article of the Constitution is Article 1. This establishes the legislature. It's a bicameral legislature in which the House of Representatives would be apportioned by population. Each representative serves a 2-year term, and they are elected directly by the people. In contrast, the upper house is the Senate, where they are equal representation. Each state gets 2 senators. They serve for 6-year terms, and originally when the Constitution was written, state legislators would choose their senators. And during the Progressive Era, the 17th Amendment was passed, which provided for the direct popular election of senators. The Congress, to pass a law, it needs to pass both houses. Revenue bills must begin in the House of Representatives. Then it goes to the president for signing, or veto. If the president vetoes, Congress can override that veto with a 2/3 vote. Once it gets signed into law, it is then binding law. Article 1, Section 8 of the Constitution lists a bunch of the powers. And you can think of these as powers, things that Congress can do, but also as responsibilities. These are also things that Congress is obliged to do. Most of these powers are enumerated powers, things like declaring war, coin money, raise an army and navy, etc. But Article 1, Section 8 also includes language that expands beyond these explicitly enumerated powers. For example, there is the Interstate Commerce Clause that gives Congress the ability to regulate trade and commerce between the states, which basically allows them to regulate economic activity that affects the nation as a whole. It also includes the Necessary and Proper Clause. This is also known as the Elastic Clause, and this is what says that Congress is allowed to pass any laws that are necessary and proper to carrying out its enumerated powers, right? This is so if Congress views that it is necessary and proper to pass a law, even if it is not explicitly empowered by the Constitution, if it is substantially related to the other things that Congress needs to get done, it is justified. There's also the General Welfare Clause that says that Congress should pass laws that promote the general welfare, right? This is interpreted to say that Congress should, pass laws that benefit the people as a whole. Article 1, Section 9 places certain limits on Congress. It says Congress can't do certain things. This is kind of like a proto-Bill of Rights. Congress can't deny your right to a fair trial, but by denying habeas corpus, it cannot pass a Bill of Attainder, which is a law that says you're guilty and here's your punishment. It cannot confer titles of nobility. And Article 1 also reserves, it denies certain powers to the states. States can't coin their own money, raise their own army, or conduct foreign policy. As we're looking at Article 2, we're turning to the executive branch. How are these laws going to be enforced? The Article 2 of the Constitution vests all executive power in the president and vice president, and that they should take care that the laws are faithfully executed. This is what gives the president the ability to pass executive orders, which are really directing executive agencies to carry out the acts of Congress. The executive also has the ability to appoint members of the federal judiciary as well as leaders of executive departments that are tasked with carrying out the acts of Congress. The president is also entrusted as the commander-in-chief of the armed forces as well as the head of state or the chief diplomat. So the president is in charge basically of foreign policy and military policy. All of the generals ultimately report to the elected president, right? The president, we have a system in which we have civilian control of the armed forces, right? And that our diplomacy is conducted by the president. The president is required to update Congress from time to time on the State of the Union and make policy recommendations. And in order to become president, you have to be 35 and a national-born citizen and selected by the Electoral College. We will talk more about the Electoral College in later videos, but needless to say, it is not a direct popular vote of the nation, and the various means of the Electoral College have actually changed over time. Article 2 also includes the language of impeachment, that if you are found guilty, if you are impeached by Congress, that you can be removed from office for high crimes and misdemeanors, treason, and bribery. As we move on to Article 3, we're going to turn to the judicial system. Now, Article 3 of the three branches of government is the one that has the least information. It says that judicial power will be vested in one Supreme Court and then any other court that Congress feels like establishing it. Right? The Constitution actually doesn't give us the structure of the federal judiciary that we will come to know and love. It actually just tells us that there will be a federal judiciary. Judges in the federal judiciary are given lifetime appointments or the term of good behavior. That means unless they're impeached, they die, or they retire, they can be justices as long as they want. And that the Supreme Court is the final court of appeals. Basically, it has appellate jurisdiction over the entire country, right? That if you want to appeal a decision in the state courts or the federal courts, it'll eventually work its way up to the Supreme Court, which has the final say. The end of Article 3 also says treason is bad and you shouldn't do it. The next article of the Constitution is Article 4. This governs certain relationships between the states. Includes greatest hits, like the full faith and credit clause that says that basically laws, documents, official records are valid across state lines. If you get married in California and then you move to Florida, you don't have to get married again. That you can drive, your driver's license as you're driving across the country on a road trip is valid when you cross state borders. There is also what's known as the Privileges and Immunities Clause that says that states cannot discriminate against residents of other states, that you cannot prohibit like someone from another state for buying something or staying in a hotel or entering their state. That basically guarantees a right to travel, unless you are a suspected criminal, in which if there's a warrant out for your arrest, you're technically supposed to be extradited back to your home state, or if you were an enslaved person who has escaped to freedom, that you are technically supposed to be returned. Obviously, with the abolition of slavery in the 13th Amendment, that clause is no longer in force. Article 4 also says that Congress will set the rules on how territories shall be governed and integrated as states, and says that the federal government has an obligation to guarantee a republican government to all the states, that these states are supposed to not become little fiefdoms or monarchies, but they are supposed to be empowered and accountable to the people. Now, Article 5 deals with how changes to the Constitution will be made. The framers knew that they would have to change the Constitution and make amendments as times change, and they provided two pathways of doing that. The first is the only way that we've actually successfully amended the Constitution, which is the congressional pathway, in which an amendment to the Constitution passes through by a two-thirds vote of both houses, right? So more than just a simple majority, and then is ratified by 3/4 of the states. The other way is for two-thirds of the states to petition Congress requesting a constitutional convention. That constitutional convention will then be called, amendments will be proposed, and 3/4 of the states then have to ratify the amendments. There has been no successful constitutional convention called through this mechanism. Article 6 is basically the supremacy clause. It says that federal law trumps state law and that the Constitution is the supreme law of the land. Additionally, it says that that officers of the United States will have to swear an oath of office, but that you cannot require any officer of the United States to pass a religious test. Article 7 deals with the ratification of the Constitution, and it says that when 9 of the 13 states ratify the Constitution, it goes into effect. So technically, the Constitution had gone into effect before all of the states had ratified it, but ultimately, all the states decided that it was better to be one big country, even if they had reservations about the actual Constitution themselves. Now, this doesn't mean that there wasn't a bunch of debate over it. As we know, there was a big debate over whether or not the Constitution can be ratified, and we can break down this debate into two main camps. On the one hand, we have the Federalists, that they were pro-ratification. They believed that the Constitution should be ratified. They were mostly represented more urban and business interests, and they believed that the Constitution was necessary for economic and political unity. That we were not going to be able to have a strong developing economy with the states squabbling over each other. That politically divided states were going to be more easily reconquered by European powers, and that if we wanted to be a united country, we needed to have a stronger central government. But they also argued that the constitutional structure checked abuses of powers through checks and balances and separation of power. That's Madison's argument in Federalist 51. And they also argued in Federalist 10, for example, that they praised the virtues of a representative democracy over a direct democracy. We'll talk more about that in a video where we focus on those documents. The Anti-Federalists, they didn't call themselves Anti-Federalists, they were called Anti-Federalists by the Federalists. They were against ratification. They mostly represented rural and agricultural interests, especially in the South, and their big concern was the Constitution took away a bunch of powers that the Articles of Confederation left to the states. They believed that that the states were going to be both better at protecting individual rights because they were smaller and closer to the states. They were worried about things like the Supremacy Clause, the Necessary and Proper Clause, the establishment of a federal judiciary, the establishment of a president and vice president of the United States with chief executive power. They thought that was going to take away the powers of the states, which would then in turn take away the power of individuals. They also really did believe in democracy, but they thought that was their argument for why the state should have more power, because the state, you couldn't have a democracy in a country as big as the United States as a whole. So instead, we should preserve more power to the states where they can better maintain democracy and have better democratic accountability. Now, this Federalist and Anti-Federalist debate then leads us to this last kind of big constitutional principle that we're going to talk about, and that is that of federalism. Now, federalism shouldn't be confused with the Federalists. When we are talking about federalism and not the Federalist like faction in the ratification debates, we're talking about balancing state and federal interests and powers. The Federalists generally supported expanding federal power. When we're talking about federalism, we're talking about balancing those competing interests. So federalism is really like, how are we going to balance these powers? And so a few key ideas here is the exclusive, reserved, and concurrent powers. Now, Article 1, Section 8 says that there are certain exclusive powers that only Congress can do, right? These are the enumerated powers in Article 1, Section 8, right? So if enumerated means exclusive, right? There are also powers that are reserved to the states. This is the 10th Amendment to the Constitution says that any powers not explicitly given to the Congress nor prohibited by the states get to do. So if the Constitution is silent on it, the 10th Amendment implies that this is something that should be left to the states. Then there's this idea of concurrent powers. Both the state and the federal governments can pass laws. They can raise taxes. They can, declare holidays. They can, do all sorts of things. They can establish courts. They can fund things. They can appropriate money, right? These are basically, there are going to be, in order to be a government, you have to do these things, and those are concurrent powers. Federalism itself changes over time, right? Through most of the 1800s, you have, and into the early 1900s, there was a system called dual federalism, where the powers of the federal government and the state government were relatively divided, and the federal government's powers were relatively limited. The Supreme Court tended to side with limiting the ability of the United States federal government to intervene into the economy, regulate business interests, create limitations on economic activity, and said that, like, look, if a state wants to do that, that's fine, but we should overall defer those questions to the states. In the aftermath of the Great Depression, World War II, the establishment of the creation of New Deal programs and the kind of established growth of American power both overseas and the growth of domestic social welfare states, we moved to a model of cooperative federalism. Cooperative federalism means that the states governments and the federal governments are going to be working together on more policy issues. Sometimes this is called marble cake federalism, with this image that the state and federal powers are all kind of mixed together, and sometimes we call this picket fence federalism, because it's not that they're mixed together, but that there are that you can kind of think of it more as a grid system where there are on the different levels. Those are going to create those horizontal lines, the federal, state, and local, and then in each domain, right, you're going to have experts and bureaucrats and policymakers working at the federal, state, and local level. If we're thinking about federalism, there's also three kind of ways that the federal government can shift the balance of power. The first are through categorical grants. This is where it gives money to the states in order to achieve a certain policy outcome, but does so with very strict restrictions and criteria. We want you to have this health insurance program for needy families, and here are all of the rules that you're going to have to do to follow it. Or you can do a block grant system. This is going to give the states more latitude because the government is basically saying, we want you to help fight homelessness, and here's a bunch of money that you can use to to fight homelessness. How are you going to do it? What regulations, what restrictions, what criteria, what specific policies will be up to you. That's going to give the states the most latitude. The least latitude and one that limits the power of the states the most are what are called unfunded mandates, where the federal government passes legal requirements for the states. The states have to limit air pollution or water pollution, for example, but does not explicitly appropriate money to the states for doing this. The states have to come up with the resources to implement this policy themselves. So the debate over federalism really comes down to kind of two big ideas. On the one hand, defenders of federalism, defenders of giving more power to the states and more state autonomy, will call the states laboratories of democracy, that allowing the states to experiment with different policies at the local level to fine-tune policies that are going to be best suited for their individual needs of the economies and societies and the cultures and demographics of their population is going to be good for the people overall, and it allows for democratic experimentation and innovation. That same flexibility is criticized by critics of federalism by saying that this flexibility creates a race to the bottom in which states are going to try to lower their regulations, lower their taxes, limit the powers, create a more, kind of lower their funding for public goods and welfare programs to keep their tax base low, to attract more business and population to their states, which is going to lead to a race to the bottom and worse outcomes overall. Another way we can think about this balance of power between the federal government and the state government is looking at two of our required Supreme Court decisions. The first is McCulloch versus Maryland in 1819, which concerns the creation of the Bank of the United States. And the second is the U.S. versus Lopez from, almost 200 years later, which concerns the Gun-Free School Zones Act. Now, McCulloch versus Maryland ultimately upheld the constitutionality of the bank by saying that the necessary and proper clause creates an implied power for the federal government to create a Bank of the United States, where on the other hand, and that Maryland could not tax because the power to tax is the power to destroy, and the states can't destroy an organ of the federal government because of the supremacy clause. In contrast, U.S. versus Lopez limited the power of the federal government by saying that the Interstate Commerce Clause did not apply to here, that the federal government could not claim that education constituted interstate commerce and therefore create federally regulated gun-free school zones that would make with the goal of preventing school shootings. Because even if school shootings are terrible, that they do not constitute interstate commerce, right? So we can see how the court can increase or decrease federal power, give more power to the state through rulings on kind of 10th Amendment, necessary and proper clause, interstate commerce clause, supremacy clause, etc. All right, so the last thing here is to double check your understanding. This is what you should be able to do for this unit. So use this checklist as a way for you to study. Make sure that you feel confident being able to do all of these things, and tune in for the next video on Unit 2, in which we'll be talking about the specific checks and balances and the structure of the federal government, as well as how each branch of government has an effect on policymaking.